applied for this. We have not had an incident of it. If there's something that is lacking, why not build it into state law first, and instead of going to the most dramatic remedy, which is to change the Constitution, if we have not encountered these difficulties?
Well, first of all, the league is not correct, although I'm glad that they're opposing it this year, because for the last 4 sessions, they've actually opposed it while being neutral. They're not correct on the current law. There are 3 tests: public use, public purpose, and public benefit. Public purpose is what was allowed in Kelo versus New London, Connecticut. Public benefit has been upheld by the North Carolina Supreme Court for North Carolina in the FedEx case. Representative Jones is from Greensboro, and he knows that FedEx, the government was allowed to condemn for property to convey to FedEx. So it's not correct to say that it hadn't happened. Gaston County, right recently, a year ago, Will Newman and David Hoyle were concerned about the fact that Gastonia was going to condemn a bank building for economic development, and I think they settled it and didn't do it. And right here in GS 48-3, which is the principal condemnation statute for North Carolina, it's not DOT. Of course, DOT is always the public use. 40A is, you know, our most used condemnation case right here for the public use or benefit, or OR, disjunctive benefit. The persons or organizations listed below shall have the power of eminent domain, and it lists them there. That's for private condemnors, and to B, it's under local public condemnors for the public use or benefit. Other public condemnors, I mean, it's right there. So the fact that they've been a little loath to use it in the last 4 or 5 years because they know 90% of the public opposes it, it's not factually or legally true to say that we don't have the statutory or constitutional authority to do economic development condemnation in North Carolina. It's there, it can be done, and it needs to be put a stop to. And I'll close with this. In Texas, 6 months ago, 81% of the people voted for something almost like this. It was supported on a bipartisan basis, and they put a stop to it.
Follow-up, Representative. But I'm not sure that it quite gets to my basic question.
Well, the question is,
if we the general statute first, before you resort to a change in the state constitution, can we not remedy the potential for a problem by addressing the general statute?
Okay, good question. And that's what was advertised in 2006 with the Wilma Sherrill, Bruce Goforth bill, that we cleansed our statute of this. But it's not. And number two, in discussing this with one of the leaders who was opposed to it, I asked him, well, why would you ever want to do this? He says, well, what if some big company wants to come in and get 1,000 acres, and there's some family right in the middle of it that you know, won't sell their 2 acres. We've got to be able to do something. And that's just the point, is we have to have this in the Constitution so that when everybody's in a hue and a cry to bring in some big company, that we don't take some family's homestead just for temporary economic effect. And we got to have this in the statutes. Now, listen, in communist China, they're crying out, they're winning this case. It's on the front page of the People's Daily over there, the fight against this kind of thing. You know, we have a long history. Now, by the way, there's another provision in the bill. We are the only state in the nation that does not provide for jury trial in cases of condemnation by Constitution. There's 49 states that do.